County of Dakota, State of Minnesota Court, the First Judicial District is now in session. General Carnhouse Club presiding. You may be seated.
Good morning, everyone. Mrs. Keena, did you wish to approach?
Are we using your podiums this morning, or are we going to stay?
I'm going to, if you'd be seated at this point, when I invite you up to make your argument, you'll be using the podiums. So, let's call the State of Minnesota and Sandra Grazzini-Rucki, file HACR 15-2669. Counsel, please note your appearances.
Captain Keena on behalf of the state.
Stephen Grigsby on behalf of Ms. Grazzini-Rucki.
We're scheduled for sentencing today. Ms. Grazzini-Rucki was convicted of counts 1 through 6 of the criminal complaint following a jury trial. She was found not guilty of counts 7 and 8. Following the return of the jury verdict, a pre-sentence investigation and psychological evaluation were ordered. Reports have been filed by both the Community Corrections Department and the forensic psychologist who conducted the psychological evaluation. Counsel, have you received copies of each?
The state has, Your Honor. There was an amended PSI that was filed.
I believe there was yesterday, in light of the fact, I believe the PSI writer reviewed the order for an amendment of the complaint and adjusted her recommendations accordingly.
Correct. And the state has received the amended PSI and the psychological evaluation, and the state did bring that the fact that the probation agent used the complaint rather than looking at the amended order or the order amending the complaint, brought that to our attention. And in addition, in looking at the credit for jail time, the PSI provides for 114 days. I was reviewing that again yesterday afternoon, and according to my calculations, the jail credit should be 133 days. I don't believe the PSI writer took into account the in-custody time that Ms. Grazzini-Rucki spent in Florida when initially arrested.
All right. Mr. Grigsby.
I've received a copy of the PSI and the psychological evaluation.
All right. Do you concur with the 133-day
Yes, Your Honor.
custodial credit time?
Yes, Your Honor.
All right. Is the state ready to proceed to sentencing?
It is, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor.
Ms. Keena.
Your Honor, before making my sentencing argument, do you first want to hear victim impact statement, or would you prefer to have that at the end?
I'm very willing to listen to the victim impact statement at this time.
Okay. At this time, David Rucki would like to provide a victim impact statement, and would you like him at the podium?
Yes, please. Mr. Rucki, why don't you step forward, please? If you'd be kind enough to step forward here. Good morning.
Good morning.
Mr. Rucki, go ahead.
Bear with me, I'm not a prolific reader, and I don't do this very often.
Take your time.
I just wanted to start by thanking a few people. For if it wasn't for the support of these people, my daughters Samantha and Gianna might never have been found, and I would not have survived this ordeal. I would first like to thank my parents, my sister Tammy, my cousin Tom, and my friend Tony Canny for all the emotional support. Lisa Elliott and her law firm, the Lakeville Police Department, Chief Long, Lieutenant Polinsky, and Detective Dronin. The Center of Missing and Exploited Children, Jane Strube and the Wetterling Resource Center, the Star and Tribune, Brandon Stahl, Michael Broadcorp, Charlotte Lippa, and transitioning families. One of the goals of the victim impact statement is to provide an opportunity of the victim to communicate with the judge and the offender on how the crimes have impacted the victim. There are many victims in this case. The ones who matter the most are our 5 children, Nico, Samantha, Gianna, Nia, and Gino. After reading my first draft of the victim impact statement I wrote, I realized that I'd made a mistake. Including in my initial victim impact statement were numerous examples of how Sandy had spent years focusing solely on her selfish pursuit of destroying the family and the life we had spent building together. But the woman who appears in this courtroom today is not the same woman I married 25 years ago. Sadly, that woman is gone. I would be wasting the time of everybody in this courtroom today if I detailed how 5 years ago the woman I had married and had 5 beautiful kids with suddenly became the woman who she is now, a convicted felon. A woman who conspired with others to hide 2 of our precious children from their father, their family, and their friends for 944 days. If I believed my victim impact statement would have had an impact on Sandy, I would have made a direct appeal to her to realize how blessed she is to have 5 healthy, beautiful, and strong kids. I would have asked her to get the help she desperately needs to begin repairing the damage she has caused to her family, our family. My words are lost on Sandy. I have no doubt she can't even comprehend the pain and the trauma she has inflicted on her children. I have a sliver of hope that the sentence of this court will free Sandy from her distorted views of reality. A jury of her peers heard the overwhelming evidence presented against Sandy to convict her on the 6 counts of deprivation of parental rights. Sandy no longer understands what it means to be a parent, and therefore I do not believe she understands what she took from me, or more importantly, our children. To this day, I still do not understand why Sandy thought complete annihilation of our family was a good plan. She needed to first destroy me, the father of her children. In order to do so, she used our children, not appreciating that she was destroying them in the process. Nico was forced by Sandy to write false claims about me on his Facebook, which embarrassed our son with all his friends and filled him with enormous guilt. He was torn between the desire of trust and belief in his mother and his need to tell and finally tell the truth. He has done what he can to make sure his words, the words he knows, He has done what he can to make sure the world knows that the words on his Facebook page were not his. They were not the truth. They were his mother's words. She used him to try to hurt me, destroy my reputation, destroy my relationship with my children. I thank God every day that Nico and all our children are finally able to recognize the truth from the nightmare Sandy created. Sandy has also used Samantha and her web of destruction against me. One day she took Samantha out of school on the promise to go shopping, skipping school to go shopping. Instead of a shopping trip, she made Samantha, who was 15 at the time, distribute my personal financial information, distributing corporate checks, background information, social security number on the streets throughout the metro area, all part of Sandy's attempt to destroy me financially. Sandy refused to follow the advice of the family court, the guardian of our children, and therapist, who were instructed us both to participate in parenting classes, to undergo chemical and mental health assessment. These professionals desperately wanted to help our family, help our children. Sandy turned her nose up at anything that would have stopped her plan of destruction. While I was following the instruction of the family court to heal our family, Sandy was creating an environment of paranoia and fear in our children. Sandy went to great lengths to convince our children that the world that I was a monster. During this time, our children should have been focused on school, on their friends, having fun, and growing up. The time was spent being used by their mother to destroy their father. As to the long-term effect, what you did to our children, this will take them years, if not a lifetime, to comprehend the trauma and the pain you inflicted upon them. But sadly, our kids may be haunted for this the rest of their lives and will possibly never understand why their mother didn't just let them have the love and support of both their parents. In the attempt to destroy the children's relationship with me, you have ultimately destroyed your own relationship with them. You haven't seen or talked to Nico, Nia, or Gino for almost 4 years. You've missed so much. You have already missed so much. Nico has grown to be an amazing young man who makes me so proud. Gino and Nia are a delight to watch growing up. What you did to Samantha and Gianna is unforgivable. You stole 2.5 years of their childhood from them. Time they'll never get back. Time will never get back. For 944 days, 2 of my kids were away from those who loved them the most. They were living in a desolate part of Minnesota with complete strangers. They didn't see a doctor. They didn't go to school. They didn't see any of their friends, and they didn't see any of their family. During this time the kids were missing, life moved all around me. But I was consistently numb in a perpetual state of shock. I saw an example of the best and the worst of humanity. I watched complete strangers take up the cause of helping me find my missing kids. One of the worst days during this 944 days my girls were missing is when Trish Van Pilsen from Fox 9 showed up uninvited to my home. My daughters had been missing for 10 days, and law enforcement was working with me and my family to help find them. At the end of the interview, Van Pilsen told me that she had interviewed the missing girls but she refused to share the information on the location with me and law enforcement. She left me helpless. Knowing that she alone could help bring me to my girls, yet hiding behind the shield of journalistic integrity, she had the power to end this nightmare in just 10 days. Instead, it lasted 934 days. During that 944 days my daughters were missing, I needed to be a father to all our children. Despite 2 seats at the dinner table always being empty, I lived at the home like our family Sandy attempted to destroy. Even after repairing all the damage to the home, 2 of our kids were still missing. Even when it was noisy in the house, there was missing 2 voices. Even when the house was full, 2 were missing. 944 days with 2 missing. It was a living hell, a hell that Sandy designed and built as a vehicle to battle her own personal demons and enemies she created in her mind. Received a phone call from the Lakeville Police Department asking me to collect DNA and dental records for my missing girls was one of the lowest points. The wave of reality that my girls may never be found, or worse, may never be found alive, became a sudden reality. I wish I could go back in time and get Sandy the help she needs. While she is my ex-wife, she is the mother of my children. I want them to have a mother who truly loves them, as the children should be loved by both parents. Unlike Sandy, I understand that being a parent means thinking about the welfare of the children before yourself. For me, this will fade. I will leave the courtroom today, and I will talk with my 5 kids. I will ask them about their day. I will talk to them about school, their friends, and their life. I will continue to enjoy raising our family. We will discuss the punishment their mother received, and it will be brief. Our children haven't had a real mother in years. Their mother has been gone so long that her being in jail or on probation won't even really impact their lives. I've been able to feel the warm embrace of each of my kids tonight, and that will be something she hasn't felt in a long time. Regardless of the sentence today, Sandy is facing a lifetime sentence of the loss of the most precious thing in life, the life with her children. She gave that up long ago. It wasn't the corruption of the family court that prevented Sandy from seeing her children. It was just Sandy. I want to thank the jurors who thoughtfully rendered their guilty verdict in the case, and the Dakota County Attorney's Office, especially Kathy Keena and Jim Backstrom. Your Honor, thank you for ensuring the trial and the conduct Thank you for ensuring the trial was conducted with dignity and your consideration for my children and family. Your Honor, today we are here for the sentencing of Sandra. We are here to learn of her punishment. I do not know what the guidelines exist in the rules for this crime. I believe the old saying, about punishment fitting the crime. The crime here is simple: 944 days. What I was deprived of my rights to parenting my daughters, 944 days of fear, desperation, longing to hold them and keep them safe. I was deprived of something for close to 140 Sundays, 944 days of dinners, family dinners, and I was deprived of 944 mornings and yawns and goodnight kisses. Your Honor, I do not know what sentencing you will choose to impose. I do ask your consideration, you to consider every last one of those 944 days. Every missed opportunity to hug my girls and keep them safe. Maybe the law prevents you from sentencing Sandy to 944 days in jail, or for her to think about the pain she has caused for all of us. Maybe you can't take 944 sunrises and sunsets from her. In the case, I just simply ask that you impose the highest level of penalty you are permitted. Finally, I want to speak directly to my children. You are the reason I made it through this. You are the light at the end of every day. You are my strength, my joy, my life. I would do this again 100 times if I had to, because it would mean at the end I would have you. I would have all 5 of you. Thank you.
Thank you, Mr. Ms. Keena.
Thank you, Your Honor. Your Honor, I would like to echo some of the comments made by Mr. Rucki during his victim impact statement and take a moment to thank some agencies and people that were instrumental in bringing Sandra Grazzini-Rucki to justice. I would first like to take this opportunity to thank the Lakeville Police Department and the U.S. Marshals Service for their efforts in locating Sammy and Gianna Rucki and bringing them home. I would like to commend the efforts of Michael Broadcorp and Brandon Stahl of the Star Tribune. Had it not been for their efforts, we never may have located the girls. They provided us with information that caused a major break in the case that allowed us to pursue this prosecution. I would like to thank Lisa Elliott, Mr. Rucki's family law attorney, for her tenacity and tireless efforts in seeking information in the family court case as to the whereabouts of the girls. I would also like to thank Lisa and her staff for the assistance that was invaluable to me during my trial preparation for this prosecution. When one looks at this case, after completing the trial, I told folks in my office this was more complex and complicated than trying a first-degree murder case because of all the tentacles and all the family court issues. Finally, I would like to commend the efforts of David Rucki, a father who never gave up hope and whose resolve and persistence served to keep the rest of us focused on locating his daughters and bringing those responsible to justice. As to the sentence the defendant should receive in this case, the Minnesota sentencing guidelines limits what the state may request and limits what the court may order. The deprivation of parental right crimes the defendant was convicted of are all severity level 1 offenses, the least serious level under the sentencing guidelines. Because the defendant has no criminal history points, the most jail time she can be required to serve is 1 year and 1 day. So unfortunately, Mr. Rucki's wish of 944 days is not an option in this case. In no way does a sentence authorized under the sentencing guidelines adequately address or reflect the seriousness of the defendant's actions in this case, as outlined by Mr. Rucki. Be that as may, the state is required to argue for a sentence that meets the parameters of the sentencing guidelines. With that in mind, the first question that needs to be addressed is what counts this court may enter convictions on. Minnesota Statute 609.035 provides that if a person's conduct constitutes more than one offense under the laws of this state, the person may be punished for only one of those offenses. However, there is an exception to that rule, and that exception is the multiple victim exception. Under that exception, courts are not prevented from giving a defendant multiple sentences for multiple crimes arising out of a single behavioral incident if, 1, the crime affects multiple victims, and 2, multiple sentences do not unfairly exaggerate the criminality of the defendant's conduct. With that exception in mind, the state is as to Gianna Rucki. Now, conceivably, there are many victims in this case, but when we're trying to determine the victims for purposes of entering convictions, the state believes that the cleanest, bulletproof, if you will, way of doing this is to focus on whose rights were actually deprived here, and look at those people as the victims in this case for purposes of sentencing. So that would be David Rucki and Tammy Love. As to the sentence itself, the state is requesting the court to follow the recommendations of the PSI with some exceptions. First, rather than stacking the probationary term as recommended by probation, the state is requesting that the defendant just simply be placed on probation for a period of 4 years, which the court is allowed to do under 609.035. The court has the authority to either, the statute provides that the court can place a person on probation for either 4 years or whatever the maximum sentence is, whichever is longer. In this case, the maximum sentence is 2 years for the crime, and so the state is just simply requesting that it be a 4-year probationary term. Second, that the defendant be required to serve 133 days in jail, credit for time served, which she has satisfied that requirement. And Your Honor, the PSI was recommending additional jail time, and specifically was recommending that the defendant serve 30 days jail commencing on April 19th of each year that she is on probation. And obviously the significance of that date is that that is the date that the girls went missing back in 2013. While I appreciate the rationale behind that, I personally made a promise to a young woman who was a witness in this case, that when I met with her and saw the trauma that she was going through and experiencing with the thought of having to appear in the courtroom and testify against her mother, I made her a promise that I would not request any additional jail time. And I'm going to keep that promise.
I want to be very clear that the court did not engage in this promise, and the court is learning of it for the first time today.
And Your Honor, I advised her that that wasn't my decision, and that ultimately was the court's decision.
All right.
But I'm just personally, I made that very clear to her.
All right.
The other reason why the state is not requesting any additional jail time is, with having served 133 days, Sandra Grazzini-Rucki has basically, if you include good time, has basically served approximately 6.5 months. And with only a year and a day of jail hanging over her head, the state feels it's also important to have an adequate amount of time hanging over her head to serve as an incentive for her to comply with her conditions of probation. However, that doesn't prohibit the court from sentencing her for more jail time, but the state would also ask the court to consider sentencing alternatives. And specifically, the state is requesting that the defendant be required to serve 30 days in the sentence to service program, and that be completed on or before December 31st, 2016. The PSI recommends no contact with David Rucki. The state is requesting that that be expanded to include no contact, direct or indirect, with Tammy Love, and that she be prohibited from having contact, either direct or indirect, with Samantha Rucki unless approved by the probation department. The state is also requesting that the defendant and anyone at her direction be prohibited from engaging in any harassing conduct against David Rucki, their children, and Tammy Love, and that would include any internet postings. We have reason to believe that Ms. Grazzini-Rucki has been making postings on a vacation rental by owner site that Tammy Love has, and has been posting negative comments about supposed stays that did not occur. We also have information that Sandra Grazzini-Rucki provided a copy of Samantha's interview that was provided in this case, provided that to so-called bloggers and which were posted on the internet. It's that type of harassing conduct that the state is asking the court to prohibit her from engaging in. Finally, there is the Crime Victims Reparations Board paid out $10,000 in this case to Mr. Rucki, and that pertained to the reunification costs, and there was $5,000 for each child. The state is requesting that that be made joint and several with any co-defendants that may be convicted, namely Deidre Evavold and Gina and Doug Dolan. Thank you, Your Honor.
Does the state rest? Mr. Grigsby.
Thank you. Good morning, Your Honor. I'm going to sort of just outline what I think are the technical legal parameters for the sentencing. I don't disagree in essence with what the state said, but I think that there's some important distinctions, and that it's clear here that this is a single behavioral incident with a single criminal objective, but there is an exception for the multiple victim. And what that would allow the court to do would be to sentence consecutively if there are multiple victims, and I agree technically there are two victims. There are two people who are rights holders pursuant to court order, Tammy Love and David Rucki. But there's also an important dimension to that, and that the court cannot apply the multiple victim exception if it would unfairly exaggerate the criminality. Now, let me say this in support of that. As a technical victim, Tammy Love is essentially just that. She was never a custodial parent. She was not a surrogate custodial parent. She was a person who the court decided to entrust the children's custody to on a very temporary basis, and it was in fact a temporary basis and was eventually given to the father. Now, the reason why that happened is because in the family court proceedings, the court had decided at that point that the father was not suitable at that time to be the custodial parent. So what I'm suggesting is that the court does not give us any strong, clear definition of what would unfairly exaggerate. So we have to, in some way, sense of what the most common sense would be. The most common sense meaning is that if it would unfairly exaggerate if you were to take somebody who is a technical or a virtual victim and treat that person as somebody who is sufficiently involved and sufficiently injured by the criminal conduct to warrant a consecutive sentence. And I respectfully suggest to the court that as a technical matter, this would be an example where consecutive sentences with Tammy Love as the secondary victim would unfairly exaggerate the nature of this sentence.
Your Honor, may we approach? Yes.
I'd like the microphone to be, can we cut off the microphone, please?
Thank you, Your Honor. Moving on to my next point, that I want to emphasize, despite the fact that in every situation where a person commits a crime and there's a victim of this crime, and that victim is Mr. Rucki, and he explained to the court precisely in what terms he fairly is a victim of this crime, that there are nevertheless factors to consider in mitigation. First, that the only evidence that we have of what started this was a very unusual, contingent, sort of a spontaneous affair, where the children, the two daughters, reacted badly to the court's custody order, ran into the streets without their shoes on, afraid, and then begged their mother to help them. Now, whatever judgment, whatever error of judgment that resulted in the conviction that Ms. Grazzini-Rucki, that the evidence showed Ms. Grazzini-Rucki committed after that, the original situation was in essence untenable. There was really no good way out. She was prohibited at that time from having conduct, and the girls gave her essentially an ultimatum: you either help us or we're going to run anyway. Now, I think that in essence, the jury's verdict reflects in some part an agreement with the initial conduct. But I say that because I think it's pertinent to whether or not there's the possibility of reoffense in the conditions of probation. The PSI has identified no factors to suggest that she's at risk for reoffense. And indeed, the kind of situation that prompted the chain of events that led to the conviction here are almost certainly never likely to recur again. I don't think there's any objection on behalf of the defendant, Ms. Grazzini-Rucki, to a no-contact order with either Tammy Love or David Rucki. I don't think that this is a problem. But I think it is a problem when Samantha Rucki, who has not been here or nor offered, was contacted to offer her opinion, who's now, I believe, 18-year-old and at the age of majority. She's not technically a victim of this case. And there's no evidence before the court that this would actually even be in the interest of Samantha Grazzini-Rucki. And I don't think the court would be within its authority to impose a no-contact order on somebody who has not offered an opinion about whether that contact order is even desired or not. Certainly, it's reasonable that there are family court orders in place that would have to be followed, whether they're conditions of probations or not. There's no objection to having those continue as a condition of probation. But I also want to suggest that I heard the court sort of suggest that it was not party to the promise, and that's absolutely true. And I don't know if that was indication.
Suggested. I stated emphatically.
Correct. And there's no doubt that is, there was no question, whatever prosecutor's promises are made, that the prosecutor does not do the sentencing here. So in essence, I got the sense, right or wrong, that the court did not mention that emphatically, because the court did not believe that that was a sufficient punishment in this case. In essence, Ms. Grazzini-Rucki was given sort of what would be a standard average punishment long before the trial happened through her pretrial incarceration. She only has the balance of a probationary term to serve yet. And so the court, when it comes down to, the court has a decision with respect to the entirety of the sentence, but in the harshest term, which is the term of incarceration. The court can essentially maximize the term of incarceration, which would be to impose the absolute harshest penalty the court can impose on Ms. Grazzini-Rucki that the law allows. And I think in this case, that type of harshness is not justified. And I think that there's sort of a tendency to say, well, if the crime is really bad, then somehow it inevitably follows that the punishment may be bad. And the notion is that bad things beget other bad things. And I think, but there's a skip side to that one too. And that is that there's an unpublished opinion out there, and I only cite it in the abstract that way, that talks about the quality of mercy that the court can perform. And I understand, and I've been around long enough to hear the response to that, which is that, well, did the defendant show mercy to the victim? And the answer to that question is absolutely not. And so what the court can do is the court can do one of two things. The court can say, well, I'm simply going to act primarily out of satisfying the desire for vengeance of the victim and to inflict as much harm, and in the harshest term, that the court can allow, because bad things beget bad things. But the other side to that is also mercy begets mercy, and grace begets grace. And that we all come into court here, and we always expect, at least my clients do, and every other defendant, fears the power of the court, understands that the court can inflict pretty serious, irrecoverable punishment upon a person, that is that deprivation of liberty. But it doesn't always have to be that way, that there's another logic to punishment. And the logic is redemption, and the logic is the future. At some point, the children, Grazzini-Rucki children, don't want to necessarily today have a judgment from this court that errs on the side of foreclosing a future relationship. That even as you get older, even in your 50s, 60s, if your parents are still alive, these relationships are precious. And it seems to me that with the probationary term, the court can satisfy whatever supervisory powers the court has with respect to Ms. Grazzini-Rucki. But to err on the side of the harshest sentence is in essence to say, I'm simply foreclosing the future with you. I'm going to punish you maximally. I'm going to wash my hands of it and let the future take place. Well, defendants don't expect mercy, especially when a victim like Mr. Rucki gives a moving statement with respect to the children, and everybody expects the harshest penalty. But I suggest to the court that it's written nowhere that says the quality of mercy cannot beget an additional mercy, an additional grace. And I would ask the court to consider that in terms of sending a message to Ms. Grazzini-Rucki that fairly punishes her, that fairly supervises her, but tells her that the future is also important and that this is an opportunity for redemption and not just simply enduring the court's punishment. Thank you very much.
Thank you, Mr. Grigsby. Does Ms. Grazzini-Rucki wish to speak?
No.
All right. I would like to invite the PSI writer, Ms. Olson. All right, thank you. Would you step forward, please? Thank you for being here today. You are Lydia Olson, you are the PSI writer, is that correct?
Yes, Your Honor.
And we have received copies, I have received copies both of the original pre-sentence investigation report and your amended report filed yesterday. You have been in the courtroom, you've had the benefit of hearing the presentations here today by Ms. Keena, Mr. Rucki, and Mr. Grigsby. Do any of those arguments or presentations change your recommendations?
They do not, Your Honor. I would change the jail credit to 133 days. I did not account for the time served in Florida. And also, after hearing Ms. Keena, it does make more sense to sentence on count 1 and 3.
All right. All right, thank you for being here. Let me have you take a seat. Mhm.
I just have one question.
Yes, yes.
Thank you.
I invite you to stand for sentencing. Why don't you come up to the podium, please? During this morning's hearing, I was deeply affected by Mr. Rucki's victim impact statement. First, Mr. Rucki, in his eloquent and heartfelt tribute to family, the strength of family, and to his children, described his relationship with the 5 Rucki children, the 5 Rucki offspring, who I have learned are vibrant and unique individuals, each in their own right. He lovingly described his relationship with his children, and he described the impact of the events that led us to this day. Mr. Rucki described defendants' acts as the annihilation of the family. Truer words have never been spoken. The senselessness of these events have haunted each member of the Rucki family since April 19, 2013. The pain and the loss that each family member has endured is beyond comprehension. My heart aches for you. We do not live in isolation, and surely we are all reminded today of the ripple effect that one life has upon others. I was also touched by Mr. Rucki's words about a family that endures, a family that heals from trauma and pain. This is never an easy process, and it's often a process that bumps along, lurches along, 2 steps forward, 1 step back. A sentence will never heal the wounds that Mr. Rucki and the children have suffered. A sentence will not bring back precious time that was lost and experiences large and small that you all should have shared together. A sentence will not take away that pain. Ms. Grazzini-Rucki, the jury's verdict was clear. You were found guilty of 6 counts of deprivation of custodial or parental rights. During the trial, you claimed, and you have always claimed, that you acted in the best interests of your daughters, that you acted as a loving mother. If so, it defies logic that you left your 3 other children in the custody of the father you claim was abusive. Your animosity for Mr. Rucki robbed you of good judgment, and it robbed your children of stable sibling relationships and the important connection to their father during formative teen years. Your animus towards Mr. Rucki spilled onto others, including the professionals whose paths crossed yours. There is a saying, my way or the highway. And on April 19, 2013, you literally took to the highway with your 2 daughters because you did not get your way in the family court proceeding. And those 2 children remained missing for 944 days. The family is the cornerstone of our society. I'm not a psychologist, a social worker, or an expert on child development. I am, however, a mother, a grandmother, and a judge. I believe without hesitation that our community, our children, your children, need and deserve the guidance and love that a father brings to their lives. Mr. Rucki was deprived of parental rights to 2 of his precious children for 944 days. And it is true that the law, in terms of these crimes, recognized the victims as being Mr. Rucki and Tammy Love. The true victims include your children, all of your children, especially Samantha, and Gianna most directly, but also the 3 children who were left behind and who remained behind. In sentencing you today, I have tried, to the best of my ability, to base the sentence on the facts of the case, taking into account all of the circumstances that are legally relevant. My sentence is based on the facts and the law. I strive by this sentence to do justice, a concept on which reasonable people can differ, but a concept that is based on fairness, on accountability, and on community standards, as those standards are codified in law. The starting point for determining the sentence is this, and indeed in this, and indeed in every criminal case, is the Minnesota Sentencing Guidelines. The Minnesota Sentencing Guidelines establish presumptive sentences that specify the duration and the type of disposition. The sentencing ranges provided in the guidelines are presumed to be appropriate for the crimes to which they apply. And under Minnesota law, judges are instructed to pronounce a sentence within the applicable range unless there are substantial and compelling circumstances that support a departure from the guidelines. In this case, deprivation of parental rights is a severity level 1 crime. You stand before the court with a criminal history score of 0. The Minnesota Sentencing Guidelines call for a presumptive stayed sentence of 1 year and 1 day. In other words, the sentencing guidelines presume a probationary sentence. I find that a dispositional departure from the guidelines is not appropriate in this case, and I am going to comply with the Minnesota Sentencing Guidelines and not depart whatsoever from a guideline sentence. I thank the PSI writer Lydia Olson for preparing a thoughtful report and for making well-reasoned recommendations for sentencing. I also thank Dr. Gregory Hansen for his thorough and insightful psychological evaluation of Ms. Grazzini-Rucki. Sandra Grazzini-Rucki, having been convicted in count 1 of depriving another of parental rights, concealing a minor, your daughter Samantha, from her parent, you are adjudicated guilty of that offense. You are sentenced to serve 12 months and 1 day in the custody of the Commissioner of Corrections. Execution of sentence is stayed, and you are placed on probation to the Dakota County Community Corrections Department for a period of 3 years. Having been convicted in count 3 of depriving another of custodial rights, concealing your daughter Gianna from her custodian, Miss Love, you are adjudicated guilty of that offense. You are sentenced to serve 12 months and 1 day in the custody of the Commissioner of Corrections. Execution of the sentence is stayed, and you are placed on probation to the Dakota County Community Corrections Department for a period of 3 years. Your probationary period on count 2 will run consecutive to your probation on count 1. So your total probationary term is a term of 6 years. You will not receive an early discharge from probation. Should your prison sentences be executed, they will be served concurrently. The terms of your probation on count 3 are identical to the probation conditions on count 1. I am going to be imposing sentence to service and confinement periods for each year of your sentence, and the confinement periods, the annual confinement periods on each count will be served concurrently, as will your annual requirement to perform sentence to service. So, as to the conditions of your probation. First, you will serve 250 days in the Dakota County Jail. You will receive credit for 133 days actually served. By my tally, you have 34 days to serve on the original term of confinement, and you will be taken into custody today to serve the balance of this confinement period. You will serve 15 days in jail during each year of your probationary term, and your 15-year jail sentence will begin on November 18 of each year, the day the girls were recovered, beginning in 2017. So this day is the anniversary of the day the girls were recovered and returned to the care of their father. Your sentence on count 2 is consecutive to count 1, as I said, for a total probationary term of 6 years. So you will surrender to the Dakota County Jail at 8 a.m. to serve 15 days on each of the following days: November 18, 2017, November 18, 2018, November 18, 2019, November 18, 2020, November 18, 2021, and November 18, 2020. You will serve 12 days of sentence to service during each year of your probation, beginning in 2017. You will complete all 12 days of sentence to service by November 17 of each year. If you fail to complete each and every day of your sentence to service by November 17 of each year, you will surrender to the Dakota County Jail on November 18 of that year and serve 12 additional days in jail above and beyond the 15-day annual confinement period. You will pay restitution to the Minnesota Crime Victims Reparations Board in the amount of $10,000. Your restitution obligation is joint and several with any other person who may ultimately be held responsible for restitution in this case. You will also pay restitution for any past or future uninsured counseling expenses incurred for therapy provided to your children and for family reunification therapy if such a claim is made. Restitution will be determined by the Dakota County Community Corrections Department. On count 1, you will pay a fine of $944, $1 for each day your daughter, Samantha, was missing. On count 3, you will pay an additional fine of $944, $1 for each day your daughter, Gianna, was missing. In addition, you will pay a surcharge of $80 as required by Minnesota law. You will have no contact of any form, direct or indirect, with David Rucki or Tammy Love, and neither you nor anyone acting at your instruction will commit any acts of harassment against either Mr. Rucki or Ms. Love. You will comply with all family court orders. You will attend individual therapy and follow the recommendations of your therapist. You will follow the rules of the probation department. You will provide a sample of your DNA. The Dakota County Community Corrections Department is authorized to release the pre-sentence investigation report and the psychological evaluation report to any court-ordered programming. There are 10 standard conditions of probation that apply to your case, and you will find them detailed in the sentencing order. You are adjudicated guilty of counts 2, 4, 5, and 6. No sentence is imposed on these counts. I wish to close with a very brief word to Samantha and Gianna. And Mr. Rucki, I hope that you will share these with your daughters. Samantha and Gianna, you are courageous, smart, strong, and resilient. You are loved and appreciated for who you are. Helen Keller said, "Character cannot be developed in ease and quiet. Only through experience of trial and suffering can the soul be strengthened, ambition inspired, and success achieved." Samantha and Gianna, you are on your ways to overcoming the conflict and the challenges of the past. I hope that you reach for your dreams and live your lives knowing that you're strong and brave. That concludes the sentencing.
One matter.
Yes.
And that is that I'm going to ask the court to stay the sentence pending an appeal. Now, the standard for doing that is, first of all, whether or not the appeal to be taken is simply for delay. Now, the court presided over this trial. The court knows that there are several legitimate issues that may not ultimately be prevailing issues, but certainly there were sufficient issues with respect to the court to make the appeal not frivolous, but something that deserves at least serious consideration. Now, the court's decision to stay this is not an attempt to sort of predict what the appellate court would do. There's simply no way that the court can do that. The court has already made the decisions that it found to be appropriate, and nobody's asking the court to review that. It's just a technical standard for deciding whether to stay the appeal or not, that if the court believes the issues are simply taken for a delay, that are on their face frivolous, then that's a reason to deny it. If the court does not find that, then the court actually has to consider then whether or not what the harm to the public would be, what the risk of flight would be, whether she's particularly dangerous and her not being in custody would endanger the public. She's a 50-year-old woman with no criminal history. The court has released her on her own recognizance back in February. The court imposed a series of conditions on her. She has complied scrupulously with each condition. After the trial, the court once again increased the bail, which forced her to go into custody, and added a series of conditions. And that series of conditions also was scrupulously abided by. In other words, we have roughly 8 months of proof that when the court gives a order and supplies conditions, that she's not only willing and able to comply, but she's done nothing other than comply with those conditions. That 8 months is an important term because that reflects on the more optimistic side the time in which the appeal would likely be heard. There can be at this point no consideration that she's a flight risk. Now she has been sentenced. She has a probationary period. She came into court today knowing that she was going to be sentenced. I have, of course, advised her that the court's what the court could do, but since she's been released, she has provided the court the exact opposite of what would be evidence of flight risk, and that is compliance. Attended every court hearing, participated in her trial, and showed up for sentencing. So I'm not asking the court to suspend the entire sentence. Whatever supervisory conditions that the court has put on probation can be made in terms of the condition of release. I asked the court to do only one term of the sentence to suspend it, and that is the part that she can't get back if she were to prevail on appeal, and that is the term of incarceration and the alternatives. So I think that if you look at the factors, there is no credible argument she's at risk to harm anybody. No criminal history, and the only time in her life when she's ever deprived somebody of rights was not an assault. It was simply the result of a transitory incident for which she's been punished if she doesn't win on appeal, that she'll have to serve. So there's no argument that she's going to harm anybody, and she's not a flight risk. There's been at least 2 opportunities for the court to see her conduct when she was at liberty to flee, and she's always showed up to court. So I'd ask the court to do everything, impose all the conditions, simply suspend the term of incarceration pending the appeal.
Ms. Keenan.
Your Honor, the state is opposed to the request for a stay, and I don't know that the rule contemplates that this court, if it does grant a stay, can grant it in the fashion that Mr. Grigsby is indicating. When I read the rule, the court can grant a stay of condition where we want all or nothing. We want all. We want the sentence imposed today so that she's on probation, and although she has not fled, she now stands convicted as a felon, and the state does believe she still poses a flight risk. And, Your Honor, the trial in this matter, while there may have been issues, this court did a
phenomenal job in trying that case. And I don't believe there's going to be any viable issues on appeal, and that it was rock solid. And I have every expectation that it will be affirmed. And the amount of time that it takes for that appeal to go through the process will be at least 1 year. And that's a huge risk, to allow her to be unsupervised out in the community for a period of 1 year.
If I may respond briefly. I have actually litigated this issue in front of the Court of Appeals, that the court only has the option of staying the entire sentence or not. In fact, I made this argument in the trial I had with Judge Wormiger, and the Court of Appeals issued a motion, an order on the motion, saying that that's not the case, that the court is free to impose any consideration that the court needs for conditions of release. The issue is not whether or not the court made the right decisions. Every court is presumed to have made the right decisions before they go to an appeal. The sole narrow issue is that there are certain dimensions of punishment that, if you prevail on appeal, ultimately renders the appeal meaningless. That you've served your time, you've been deprived of liberty. It's the exact same logic that we use routinely to punish people for taking things from victims that they can't get back. So the court doesn't have to engage in an analysis of whether you're likely or not likely to prevail on appeal. If she doesn't, she simply starts serving her sentence, the exact same one the court imposed. The sole consideration is whether or not she has the right to be spared the incarceration if she were to prevail on appeal.
The rule provides that when an appeal is filed, and of course it has not been filed, you stated your intention to do so, but the rule provides that the filing of an appeal does not stay the execution of the judgment or sentence unless the district court judge grants a stay. I decline to grant a stay at this time. I will follow up with a written order.
I think the rule also requires the court to state its reasons.
Yes, and I will follow up with a written order. Thank you. Thank you. You're remanded to the custody of the sheriff.